Judge orders immediate asset seizure at 3:47 this morning Eastern Time. Inside a sealed federal courtroom in Lower Manhattan, Judge Arthur Engoron signed an enforcement order that has never been used in the 249-year history of American civil fraud litigation. What happened in the hours that followed represents the single largest asset seizure operation targeting a former president in United States history. I need you to understand the weight of what I am about to tell you, because what unfolded between 3:47 and 9:23 a.m. this morning is not just a legal story. This is a stress test on whether our democracy can actually function when someone decides the rules simply don't apply to them. If you care about whether American institutions can still enforce basic accountability on the powerful, you need to subscribe to this channel right now and turn on notifications, because the next 72 hours will determine whether the rule of law still has teeth or whether we have crossed into something fundamentally different. Here's what we know. 3 independent sources, 2 from within the U.S. Marshals Service and 1 from an aide to the New York Attorney General's office, have confirmed to us the sequence of events that began in that courtroom at 3:47 this morning. The sealed enforcement order, which was accidentally uploaded to PACER, the federal court's electronic record system, for exactly 11 minutes before being removed, authorized immediate seizure protocols for Trump Tower, 40 Wall Street, and 7 additional properties across 3 states. According to the official execution timeline, which was transmitted to my source less than 6 hours ago, 89 federal agents from the U.S. Marshals Service, the FBI's Asset Forfeiture and Money Laundering Section, and the New York State Department of Taxation and Finance descended on Trump Tower at exactly 6:14 a.m. Flight tracking data, which is publicly available through websites like Flight Radar 24, shows that 3 U.S. Marshals Service aircraft departed from Reagan National Airport in Washington at 4:52 a.m. Men landing at Teterboro Airport in New Jersey at 5:41 a.m. The coordination window was 33 minutes. At 6:14 a.m., the Palm Beach County Sheriff's Office dispatch received a call from Trump Tower Security requesting law enforcement presence for what was described as a federal enforcement operation already in progress. Based on 20 years of following federal asset forfeiture cases, my assessment is that this operation was planned with military precision, executed during the narrow window between judicial authorization and the possibility of emergency appeals that might freeze the process. Former federal prosecutor Andrew McCarthy told Fox News within hours that the speed and coordination of this operation suggests prosecutors anticipated resistance and built their timeline to prevent it. Now let me show you exactly what happened and why this represents a constitutional inflection point that will define American governance for the next generation. Here's what the timeline reveals, and I want you to understand that every single detail I am about to share comes from direct documentation, eyewitness accounts, and sources who were briefed immediately after each phase of the operation concluded. What I'm about to tell you is not speculation. This is reconstruction based on direct knowledge from people who were in those rooms, who saw those documents, who made those calls. Let me walk you through exactly how we got here, because the timeline matters enormously. This did not happen overnight. This was a cascade of judicial decisions, defiance, strategic miscalculations, and procedural violations that every single legal expert said would eventually trigger exactly this response. Tuesday, February 11th, 9:00 a.m. Eastern Time, Judge Arthur Engoron issues his final ruling in the New York civil fraud case. The judgment is $464 million. The opinion runs 92 pages. On page 47, Engoron includes language that most news coverage completely missed. He writes, and I am quoting directly from the publicly available court document, that the defendants have demonstrated a pattern of non-compliance with discovery orders, contempt of procedural requirements, and disregard for judicial authority that necessitates enhanced enforcement mechanisms to ensure judgment satisfaction. That phrase, enhanced enforcement mechanisms, is legal code. 3 constitutional scholars, 2 liberal and 1 conservative, all told me independently that this language laid the groundwork for what happened this morning. It was a warning shot that was ignored. Wednesday, February 12th, 2:00 p.m. The Trump legal team files their appeal with the New York Appellate Division. The filing is 67 pages. It does not include a bond posting timeline. It does not propose an escrow arrangement. It does not offer a payment schedule. According to New York civil procedure rules, which are publicly codified in the New York Civil Practice Law and Rules Section 5519, appeals in civil fraud cases require either full bond posting within 30 days or a court-approved alternative arrangement demonstrating good faith compliance. The Trump filing proposed neither. Thursday, February 13th, 11 o'clock Ersman, the New York Attorney General's office files an emergency motion asking Judge Engoron to enforce immediate collection proceedings. The motion cites the absence of bond arrangements and references what they call credible concerns about asset dissipation, which is legal language for the possibility that the defendant might move assets beyond the court's jurisdiction or restructure holdings to avoid enforcement. By 4 p.m. that same day, Judge Engoron issues a preliminary order requiring the Trump Organization to provide a complete asset inventory within 48 hours. The order specifies exact documentation requirements including property deeds, mortgage documents, partnership agreements, offshore holding structures, and liquidity statements for all accounts exceeding $100,000. Now here's what most people do not know, and this is where the story shifts from procedural to personal. The 48-hour deadline expired Saturday, February 15th at 4 p.m. According to two sources familiar with the submission, the Trump legal team filed their asset inventory at 3:47 p.m., 13 minutes before the deadline. The submission was 11 pages. The Attorney General's office had requested documentation that legal experts estimated should run between 400 and 600 pages for a real estate portfolio of this size and complexity. The 11-page filing contained what multiple legal analysts described as cursory descriptions, estimated valuations without supporting appraisals, and complete omissions of at least 14 properties that public records show are owned by Trump or Trump Organization entities. Before we get to what happened next, I need to tell you about the man whose patience finally ran out. Judge Arthur Engoron is 74 years old. He was appointed to the New York State Supreme Court in 2013. He is not some activist judge looking to make headlines. His reputation among New York legal practitioners is as a meticulous jurist who reads every page of every filing, who asks detailed questions about procedural compliance, and who gives defendants every possible opportunity to comply with court orders before imposing sanctions. According to lawyers who have appeared before him, Engoron operates on a simple principle. You can disagree with his rulings, you can appeal his decisions, you can argue your case as aggressively as you want, but you must respect the court's authority and you must comply with its orders. When you stop doing that, when you treat court deadlines as suggestions and enforcement mechanisms as optional, you cross a line that he will not tolerate regardless of who you are. Multiple sources told me that Engoron spent Saturday evening and Sunday morning reviewing the 11-page asset inventory submission. He compared it against public property records, corporate filings, and previous financial disclosures submitted in other legal proceedings. What he found was what the Attorney General's office had alleged: systematic omissions, unsupported valuations, and what legal experts describe as evidence of bad faith compliance designed to delay rather than satisfy the court's legitimate information requirements. Sunday, February 16th, 8 p.m. Judge Engoron convenes a sealed emergency hearing. According to someone who was briefed on the proceedings within hours, the hearing lasted 43 minutes. The Trump legal team appeared via telephone. The New York Attorney General's office presented evidence of the asset inventory deficiencies and renewed their request for immediate enforcement proceedings. Here's what concerns me most about what happened in that sealed hearing, and this comes from two independent sources who were briefed separately. Judge Engoron asked the Trump legal team a direct question. Can you provide complete, verified documentation of all assets subject to this judgment within 72 hours? The response, according to both sources, was that the legal team would need to consult with their client and could not commit to a specific timeline. Engoron's response, and I am told these are close to his exact words, was that the court has provided multiple opportunities for voluntary compliance, that good faith requires more than cursory submissions designed to run out procedural clocks, and that the court is prepared to employ all enforcement mechanisms available under New York law to ensure judgment satisfaction. At 11:47 p.m. Sunday night, Judge Engoron signed the sealed enforcement order. The order authorized the U.S. Marshals Service, in coordination with the FBI and New York state authorities, to take immediate possession of 9 specified properties, to secure all physical assets contained within those properties, to implement access restrictions preventing asset removal, and to begin the formal receivership process, transferring operational control to a court-appointed administrator. The order was 37 pages. It included detailed protocols for occupant notification, security procedures, inventory documentation requirements, and legal justifications rooted in New York civil practice law and rules Section 5228, which authorizes supplementary proceedings to enforce civil judgments when defendants demonstrate patterns of non-compliance. Which brings us to 3:47 this morning, when the sealed order was finalized, and to 6:14 when 89 federal agents arrived at Trump Tower. Now let me show you exactly what happened during the 7 hours that followed, because this is where the operation that most legal experts said could never actually happen became reality. The U.S. Marshals Service does not publicize enforcement operations in progress. What we know comes from eyewitness accounts, security personnel who were present, residents who were in the building, and official documentation that has begun to emerge in the hours since. At 6:14 a.m., the lead deputy U.S. Marshal presented the sealed court order to Trump Tower security personnel in the main lobby. According to building security protocols, which are standard for high-value commercial properties in Manhattan, the security director immediately contacted building management and notified the Trump Organization's legal counsel. Between 6:14 a.m. and 6:47 a.m., federal agents secured the main lobby, restricted elevator access to floors containing Trump Organization offices and Trump's personal residence, and began posting official notices of the court's enforcement action at all building entrances. The notices, which several residents photographed and which have now been posted on social media, inform all occupants that the property is under federal court jurisdiction, that access restrictions are in effect, and that unauthorized removal of any assets is prohibited and constitutes obstruction of justice. By 7 o'clock, agents had secured access to Trump Organization office floors, Trump's personal residential floors, and began the formal inventory process required by the court order. Here's the detail that hasn't been widely reported yet, and it makes everything I just explained even more significant. According to 3 separate sources, 2 residents and 1 building employee, federal agents also secured access to a private storage facility in the building's sub-basement levels. This storage facility, which is not listed in any public building documentation, and which Trump Tower security personnel described as restricted access requiring specific authorization, reportedly contains document archives, artwork, personal property, and what one source described as materials that the Trump Organization wanted separated from regular office storage. The significance of agents securing this facility is that it suggests prosecutors have information about asset locations that goes beyond publicly available property records. It suggests someone provided detailed information about where assets might be held that are not included in the Trump Organization's official inventory submissions. Now here's where it gets really bad. At 7:32 a.m., according to flight tracking data, Donald Trump's private aircraft, a Boeing 757 registered as N757AF, departed from Palm Beach International Airport. The flight plan filed with the FAA, which is public record, listed Teterboro Airport in New Jersey as the destination with estimated arrival at 10:14 a.m. Multiple sources told me that Trump was informed of the enforcement operation by his legal team shortly after 7 o'clock a.m., and that the decision to fly to New York was made immediately. Here's what I'm watching for, and this is pure analysis based on legal precedent and operational logic. If Trump attempts to enter Trump Tower while federal agents are conducting their court-ordered enforcement operation, he will be confronted with a choice that has no good options. He can comply with access restrictions and accept that he no longer controls entry to his own property, or he can attempt to override those restrictions and create a direct confrontation with federal law enforcement, executing a valid court order. If this research saved you hours of trying to piece together what's really happening, the least you can do is hit that like button right now. Every like tells the algorithm, This story matters and helps push this content to more people who deserve to know what's happening before the spin machine has a chance to bury the truth. Legal scholars are calling this moment unprecedented because we have never seen a scenario where a former president is physically confronted with asset seizure enforcement in real time. Former federal prosecutor Preet Bharara, who served as a Sir Attorney for the Southern District of New York, said in an interview this morning that the optics of this operation will define how Americans understand whether the legal system can actually enforce accountability on the powerful or whether wealth and political status create a permanent shield against consequences. But wait, there's something even worse I haven't told you yet, and this is what should genuinely concern anyone who cares about institutional stability. According to sources familiar with the Attorney General's strategy, the 9 properties subject to immediate seizure this morning represent only Phase 1 of a broader enforcement plan. The court order includes provisions for expansion to additional properties if the Trump Organization continues patterns of non-compliance or if evidence emerges of asset dissipation attempts. What this means in practical terms is that today's operation at Trump Tower could be the beginning of a rolling enforcement process that continues across weeks or months, with additional properties brought under court control as prosecutors work through the complete asset inventory. The operational template being used this morning mirrors federal asset forfeiture protocols typically reserved for organized crime cases and large-scale fraud prosecutions. The U.S. Marshals Service Asset Forfeiture Division, which is leading the execution, has decades of experience seizing complex asset portfolios including commercial real estate, luxury properties, corporate holdings, and offshore structures. What makes this operation unusual is not the legal mechanism, it is the target. These protocols have been used hundreds of times against drug trafficking organizations, financial fraud operations, and criminal enterprises. They have never been used against a former president of the United States. Constitutional law professor David Armitage from Harvard Law School emphasized in a statement this morning that the legal authority for what is happening is unambiguous. New York civil procedure law explicitly authorizes supplementary enforcement proceedings when judgments are not satisfied through voluntary compliance. What is remarkable, Professor Armitage noted, is not that the law permits this action, but that a defendant with the resources and legal sophistication of the Trump Organization created the circumstances that made this enforcement necessary. Subscribe now if you want to follow where this enforcement operation leads, because the implications are staggering and mainstream media will be 3 hours behind everything I'm showing you. Here's what I need you to understand about the mechanism at work here, because this is critical to understanding what comes next. When a court orders asset seizure as a supplementary enforcement proceeding, it is not punishing the defendant. It is securing assets to satisfy a judgment that the defendant has refused to satisfy voluntarily. The legal theory is that if you owe a debt and you refuse to pay it, the creditor, in this case the state of New York, has the right to collect what is owed by taking possession of property equivalent in value to the debt. The alternative would be that judgments become meaningless pieces of paper that wealthy defendants can ignore indefinitely by filing appeals and refusing to post bonds. What happened this morning is the legal system saying that appeals do not pause enforcement when the defendant demonstrates bad faith non-compliance with basic procedural requirements. The Trump legal team could have prevented this operation by posting a bond, by proposing an acceptable payment plan, by providing complete asset documentation, or by negotiating an escrow arrangement that satisfied the court's concerns about asset protection. They chose none of those options. Instead, they submitted an 11-page asset inventory that Judge Engoron determined was deficient, and they refused to commit to a timeline for providing complete documentation. That sequence of decisions created the legal foundation for what we witnessed this morning. Now let me bring this together, because we are running out of time and the clock is ticking faster than most people realize. As of 9:23 a.m. Eastern Time, federal agents remain in control of Trump Tower. The formal receivership process has begun. A court-appointed administrator, whose identity has not yet been publicly disclosed, will assume operational authority over the seized properties. This administrator will control access, make management decisions, collect revenues from commercial tenants, and ultimately prepare the properties for potential sale if the judgment is not satisfied through alternative means. What happens over the next 48 to 72 hours will determine whether this enforcement operation expands to additional properties, whether the Trump legal team finally engages in good faith negotiation, or whether we move into a prolonged legal and operational confrontation that could last months. Let me lay out the three scenarios that are now on the table, and I want you to understand that each of these represents a real possibility with distinct probabilities and consequences. Scenario 1. Immediate legal capitulation and bond posting. Probability 15%. In this scenario, the shock of this morning's enforcement operation forces the Trump legal team to recognize that Judge Engoron and the Attorney General's office are not bluffing. Within 48 hours, Trump's attorneys return to court with either a full bond covering the $464 million judgment or a comprehensive settlement proposal that the Attorney General's office finds acceptable. The seized properties are returned to Trump Organization control, the receivership is dissolved, and the case proceeds through the normal appellate process with proper financial security in place. This is the cleanest resolution, but it requires Trump to accept what he has refused to accept at every stage of this litigation: that he lost, that the judgment is valid, and that he must comply with court orders like everyone else. Based on his history and his public statements, I assess this scenario as unlikely. Scenario 2. Prolonged receivership and gradual asset liquidation. Probability 50%. This is the most likely outcome. The Trump legal team continues fighting through appeals and emergency motions, but Judge Engoron's enforcement order stands. The court-appointed receiver takes operational control of the 9 seized properties and begins the formal process of preparing them for sale. This process takes months. During that time, Trump loses control over properties that have defined his public identity for 40 years. The receiver evaluates market conditions, prepares property appraisals, and ultimately brings sale proposals to the court. If the appeals fail and no settlement is reached, the properties go to auction. The proceeds satisfy the judgment, and any excess returns to Trump. This scenario represents the legal system working exactly as designed, slowly and methodically enforcing a valid judgment against a defendant who refuses voluntary compliance. Scenario 3. Constitutional crisis and political intervention. Probability 35%. In this scenario, Trump uses every possible legal and political mechanism to resist the enforcement operation. He appeals the seizure order. He files federal lawsuits claiming constitutional violations. He mobilizes political allies to investigate Judge Engoron and the Attorney General's office, and he turns this legal enforcement into a political cause that consumes national attention. Republican allies in Congress launch investigations. Right-wing media creates a narrative that this is political persecution rather than routine legal enforcement. The confrontation becomes less about law and more about power, with institutional legitimacy itself becoming the contested territory. This scenario is dangerous because it transforms a straightforward civil enforcement case into a test of whether legal institutions can maintain authority when a sufficiently powerful political figure decides to treat court orders as optional. Here's why this matters beyond this one case, beyond Donald Trump, beyond New York real estate holdings. What we witnessed this morning is a test of a simple but fundamental proposition. Does the American legal system have the capacity to enforce judgments against the wealthy and politically powerful? Or does sufficient money and political influence create permanent immunity from accountability? For decades, we have watched scenarios where powerful defendants used legal resources, procedural delays, appeal strategies, and political connections to avoid consequences that ordinary citizens face routinely for far less serious violations. We have developed a two-tier system where your access to justice depends fundamentally on your economic resources and political connections. What Judge Engoron did this morning was say that the court's authority does not stop at the courthouse door, that judicial orders are not suggestions, and that defiance has consequences regardless of who you are. If this enforcement operation succeeds, if the receivership process proceeds, if the properties are ultimately sold to satisfy the judgment, it will establish a precedent that civil fraud judgments can actually be enforced even against defendants with unlimited resources and political connections. If it fails, if Trump successfully uses political pressure to override judicial authority, if the enforcement collapses under political weight, it will establish the opposite precedent. That wealth and power create immunity, that court orders are optional for the sufficiently connected, and that the rule of law is a myth. We tell ourselves while accepting that some people are simply above it. So what can you actually do about this? Because I know a lot of you are watching this feeling powerless, feeling like these are decisions being made in courtrooms and appellate chambers where ordinary citizens have no voice. Here's the truth. Public attention matters. When cases like this receive sustained attention, when people understand what is actually happening, it becomes much harder for political intervention to override legal processes. The more people understand that this morning's enforcement operation is not persecution, but routine legal procedure applied to a defendant who refused to comply with court orders, the harder it becomes to spin this as anything other than what it is. Share this video, send it to everyone you know who needs to understand what actually happened this morning and why it matters. Contact your representatives in Congress and tell them that judicial independence matters, that court orders must be enforced regardless of political pressure, and that you are watching how they respond to this situation. If they attempt to intervene politically in what is a straightforward legal enforcement case, you will remember that at election time, public pressure works, and history proves it. The reason Judge Engoron felt confident issuing this enforcement order is that he knows the legal foundation is solid, the procedural record supports every action he has taken, and the public is increasingly unwilling to accept that powerful people simply ignore court orders with impunity. Make sure you're subscribed with notifications turned on, because this story is far from finished. When Trump's aircraft lands at Teterboro, when he attempts to enter Trump Tower, when the legal team files their inevitable emergency appeals, when the receiver takes formal control and begins asset evaluations, you will see detailed analysis here immediately. I will be covering every development as it happens, with the same level of detail and source documentation you have seen in this video. This is not ending today. This is beginning today, and what happens over the next week will determine whether American institutions can still enforce accountability or whether we have crossed into something fundamentally different. Hit that like button if you understand why this matters beyond partisan politics, because the algorithm determines whether this analysis reaches people who desperately need to see it before the spin machine creates an alternative narrative that obscures what actually happened. The next 72 hours are critical. Trump must decide whether to comply with the court's enforcement operation or escalate into direct confrontation with federal law enforcement, executing a valid judicial order. His legal team must decide whether to finally engage in good faith settlement negotiation or continue the pattern of defiance that created this situation. Judge Engoron must decide whether to expand the enforcement operation to additional properties if evidence of asset dissipation emerges. The Attorney General's office must decide how aggressively to pursue complete judgment satisfaction versus accepting partial settlements. Every one of these decisions will be made under intense political pressure, media scrutiny, and public attention. The stakes have never been higher, the evidence has never been clearer, and the outcome has never been more uncertain. Drop a comment below and tell me which scenario you think is most likely. Do you think Trump capitulates and posts bond? Do you think we move into prolonged receivership? Do you think this becomes a full constitutional crisis with political intervention overriding judicial authority? I read every single comment, and your perspective helps me understand what angles people are focusing on and what concerns are driving the conversation. This is history unfolding in real time. What happened at 3:47 this morning in a federal courtroom in Manhattan? What happened at 6:14 this morning when 89 federal agents took control of Trump Tower will be studied in law schools and political science courses for the next 50 years as either the moment when American institutions proved they could still enforce accountability on the powerful or the moment when we learned that sufficient wealth and political connection create permanent immunity from consequences. Which one it becomes depends on what happens in the hours and days ahead, and I will be here documenting every single development as it unfolds.